This is Katrin with Disability Rights New York. Welcome to our podcast, Empire State of Rights, closed captioned. We are here to bring you information on the most relevant topics regarding disability rights and advocacy. Today, we welcome Jessica Barlow, Senior Staff Attorney here at Disability Rights New York. And today we are talking about the DRNY comments on the proposed rulemaking for New York State's Division of Human Rights Notice of Tenants' Rights. Jessica, thank you so much for joining us today.
Thank you for having me.
So today we're talking about the proposed rulemaking that the DHR has set forth regarding the Notice of Tenants' Rights and the comments that DRNY submitted in May. First, let's talk about what this proposed rule means in general terms and how might it affect our audience members and the public as a whole.
Absolutely. So in the most basic sense, the rule requires that housing providers provide notice to their tenants of the tenant's right to request reasonable accommodations or modifications based on their disabilities. Through our work, DRNY frequently finds that not only are tenants unaware of their rights as individuals with disabilities, but also that housing providers are often either unaware of their responsibilities or feign ignorance until pressed by tenants and/or tenant advocates. The proposed rule and notice language will positively educate tenants as well as housing providers about the protections offered by the New York State human rights law and will undoubtedly result in more individuals with disabilities being able to fully access their housing and the related amenities.
That's a good point as we're talking about the title and as even in the intro, we're talking about the tenants' rights, but the fact that this is also bringing to the attention of the homeowners or the residence owners' responsibilities is also very important. And if we can talk about this in historical terms of tenants' rights and their providers' rights, what has changed? What's the history and why is this proposal so important?
So in its regulatory statement, the impact statement, DHR acknowledges the importance of individuals with disabilities being aware of their rights and being aware of the avenues of redress if their housing provider violates those rights. And so DRNY has routinely observed that many housing providers are actually aware of their obligations under state, federal, and local law, but remain non-compliant absent threatened legal action or agency intervention. And so this proposal helps remove a property manager's ability to claim ignorance of the law as a defense, and it moves us all closer to tenants understanding their rights and how to properly enforce them.
I think enforcement is a great thing to talk about next as we talk about how if a tenant is not aware of their rights or certainly feels like maybe the rights have been violated, who do they call? Who is enforcing this and who can help them when it comes to making sure that their tenants' rights are being enforced?
So the New York State Division of Human Rights, DHR, is the enforcement agency. So they're both the ones that promulgate these rules and actually enforce them. And so individuals with disabilities could file an administrative complaint with them, and organizations like DRNY can assist individuals in filing those complaints. And then through those complaints, the Division of Human Rights can enforce the human rights law and mandate that accommodations are provided and sometimes levy fines and other things to help encourage property managers to be more compliant in the future.
And as we look at the comments that DRNY made in regards to this, we did make notice or mention of the language that's within it, specifically around having to show a disability. Talk to us about why that is problematic, especially for people who have invisible disabilities.
Absolutely. So the proposed language states, quote, "You will need to show your housing provider that you have a disability or a health problem that interferes with your use of housing," end quote. Tenants and housing providers alike may interpret the word show to mean that a tenant must physically demonstrate their disability to their housing provider. This interpretation could have a chilling effect on individuals with invisible disabilities and discourage individuals with physical disabilities who may interpret the language to mean they must unnecessarily demonstrate their conditions. Alternatively, DRNY proposed that the language be changed to that a tenant may need to inform their housing provider that they have a disability or a health problem, as we believe that that is less chilling and will have a better impact.
And when we talk about accommodations and when people are looking at a new place to live, or possibly they need to move, or even their existing home that may not be accommodating a specific need of theirs, what types of accommodations are we talking about? There are people that may not even know what's available to them, depending on what their need is. What can we point to that would be something that an accommodation is that we've dealt with in the past?
Sure. Some of the most common accommodations that we see requested are physical access accommodations, such as handrails inside a specific tenant's unit or even in the common areas of the property. We also very often see people requesting parking accommodations, such as being assigned a parking spot in the lot associated with their building that is close to their actual residential unit. We also see requests for changes in policies and generally how the property manager runs the property. And so we encourage people to think in broad terms, and it's tough sometimes to list examples because accommodations are very individualized. So generally what I advise is that if a change is feasible and reasonable, then it is worth asking your housing provider about that. And so the first step is always for the tenant to contact their property manager, preferably in writing, to ask for the accommodation that they need. And if that request is denied or they don't receive a response, then they can reach out to an organization like DRNY for help.
That's great information. And certainly, if anything changes on that, we will let our audience know. We'll drop the comments that we made in the description of this podcast. Jessica, is there anything else that you'd like to let our audience members know about today?
We just think that this is a really important change. In the past, it was really up to the tenant to know their rights or to reach out to an organization like DRNY to educate them. But this new rule places at least some responsibility on the housing provider to alert the tenant to what their rights are and how they can access accommodations. So we're really optimistic that this will have a very positive impact.
Thank you so much for sharing the information with us today, Jessica.
Thank you.
Empire State of Rights Closed Captioned has been brought to you by Disability Rights New York, your source for disability rights and advocacy. If you enjoyed our program, make sure to subscribe, like, and share this post. If there is a subject you would like us to discuss, please email podcast@drny.org or comment below. Tune in next Wednesday, where we'll bring you more information on disability rights in the state of New York. The closed captioned and ASL version of this podcast is available on our YouTube channel. To listen to more Empire State of Rights closed captioned, follow us on Apple Podcasts and Spotify.